Alex here with part 180 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. Those are the videos that is the video that contains the detailed explanation and the underlying purpose of the series. Two things that I will glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We are going into the judge's order after hearing. This is the order that we have been waiting for. All of that, I guess, back and forth on the proposed orders, the competing proposed orders, the telephonic conference over the dispute on the proposed orders has finally come to an end. We finally have a final written order. At this point, I recall my mindset being very positive. I felt very comfortable because none of the worst things that I could have possibly imagined occurred at that hearing when she had that attorney. I wasn't too pleased with the concessions that she did get, but I do recall, for the most part, maintaining the limited contact that she was supposed to have with our son. One of the things that I can recall is my wife being really upset because she felt that my ex could come all the time and see our son at the school. And she did do that. She came, as far as I can remember, every week. I don't even think, I mean, in a strange way, I almost felt like she lived in Vegas, even though she didn't. She was going to see our son in school. She was volunteering at the school. And it was causing minor issues with regards to the school specifically. They did get upset towards the end, because it was almost like she was an obsessive volunteer. And then it caused somewhat more major issues with us. I do recall some shenanigans, like she would find out when we were leaving and she would ask, where's our son going to be? Because she was trying to find any opportunity that she possibly could to say that I was denying her visitation. Kind of like right of first refusal. And I recall sending her some kind of stuff in our family wizard saying, okay, this is the same as right of first refusal. We don't have this in this case because we don't have extra exchanges. The exchanges are the problem. And it was just, the same nonsense that I would have to deal with before. But now it was like she was amped up because she had lost custody and she felt like this is how she was going to get him back. My wife was really upset because she felt, a lot of people feel like the justice system is more than it is until they go through it. And so she was starting to get those reactions that I got early on in the case when I was like, where is the justice and the morality? I mean, where is the karma? But really, the system is just kind of, I don't want to say lazy. It's just a machine. We make it out to be some kind of superhero or some kind of like almost like a godlike thing that's supposed to have us under the control that our parents were having us under. Like when we were children, we were under the control of our parents, and now that we're adults, we're under the control of the government, the court system. And to see these things being played with and to see her pushing boundaries really frustrated my wife, because she started to have those feelings of disillusionment with the government and the court system, because she was like, we just went through all this nonsense. We went through over probably 2 years of seeing him suffering. We went through a major court hearing that was an evidentiary hearing with witnesses. We went through a second court hearing where she had an attorney. We went through a telephonic conference, which we didn't know about, but we did know about the proposed order disputes. And she's like, here we are. And she's still doing it. She's still acting like she sees him every day. But the one thing that I told my wife is she can't do this every time. She hasn't moved here, even though it seems like she hasn't. She's making these trips. And eventually she's going to stop. I just didn't know how long my ex would be able to do that for. And it's true. After maybe it was 2 months, maybe 3, she just stopped coming. And I think that was just her realization that this was impossible. I recall her saying at the hearing, I have a lot of friends that are upset. My boss is upset. Everyone wants to help me. I'm going to come every week or every other week or something like that. She at the time she was saying she was going to come every weekend, like to see him every Sunday. But in reality, she was there all the time. And so anyway, I was right. I told my wife she's going to run out of gas. This is not sustainable. Even if people are paying for her to come, it's really strenuous to do that. Unless she lived here, which I don't know how I knew, but I knew she didn't. I knew she either still lived in Reno or she lived in Hawaii, one or the other, because that's where her husband was. Anyway, there was one more thing I have to mention. Because of all of that conflict that I mentioned, because my ex was coming into town, she was still sending communications to her attorney, who was sending communications to my attorney. And her attorney was still trying to extract concessions. And my attorney felt that she was pressured to cave. And it was getting way too high conflict for a free attorney. I thought that after I won that hearing and I got custody and all those other victories, I thought my ex was probably going to stop. I thought getting an attorney on my case would just cement that. I thought that I had an attorney when I won, so if I keep this a different attorney that's free, my ex will realize she just can't do what she's doing and she'll stop. So I never got an attorney thinking that this was going to continue to litigate. I got an attorney thinking that having an attorney would end the litigation. And the exact opposite happened. In fact, I do recall an email, only one email from my ex, where she insinuated that now I was going to get to know how it feels to have to pay attorney fees all the time. Now, I didn't respond to her and say, hey, she's helping me for free. But I remember seeing that, and I remember putting that kind of in the back of my mind, thinking it's the opposite. She's going to try and litigate more because she thinks it's going to cost me money. And so all of the shenanigans that were going on, my attorney had asked me to cave on some pretty big things. And it wasn't custody and it wasn't visitation, but it was letting my ex have visits anytime she was in town. And I was like, we just went through this. The judge just said this was a problem. And my attorney was just trying to avoid yet another motion. She was helping me for free, and this was turning into work. This wasn't supposed to turn into work. So I told her I'm going to take my case back over. And I did. She withdraws, I take my case back over, and I litigate it all the way to a sole legal custody situation and a termination of parental rights. So this is just, I had to do the right thing. This was just a friend. She wasn't supposed to see. This is one of the things that I think people struggle with. You become so desperate for help that you don't realize you accidentally pull all of these other people into your conflict. And I've talked to a lot of attorneys who told me, I hate helping people for free in child custody cases because it gets out of hand. It goes insane. And this was happening in this case. And I, having represented myself for years, knew what it felt like. I knew what it felt like to do all the research, to file the documents, the stress, the deadlines. And I knew how it was probably feeling for my friend to help me for free. So I felt guilty at this point because I was, rather than feel desperate and be like, I need you, please help me, which I think too many people do, I felt bad. I was like, I can't make you do all this work. This is not fair. And so I asked her, please just sub me back in. This is getting worse, not better. And I have to litigate this because I can't afford to pay somebody to do it. And it's not fair for you to do it for free. And so she substitutioned me in. We're going to talk more about that when we get to the document because I don't think you're supposed to do that. It's a really technical procedural thing that I want to talk about. But all that being said, I think we really need to now go ahead and get straight into what the judge has filed. Here we have the judge's order following June 2019 hearing. Looks like a standard introductory paragraph. On June 29th, the court held a hearing on the notice of compliance. My attorney represented me. My ex's attorney represented her. We agreed on many contested issues, with the court ruling on the remaining issues. Based on the agreement of the parties, evidence produced at the hearing, which there was none, why is this here? I mean, disturbing. This is why I put the question mark on the end of that title, relocation hearing, because I was like, what is this hearing? I mean, as far as I can remember, the only evidence that was produced was a duffel bag, which we didn't even dig through. So anyway, let's go on, guys. Please don't take this order at its word. I don't think that any evidence was taken at that hearing. So please don't let this deceive you. My strong inclination is that was just a hearing where we hashed out what the parenting plan was going to be based on the evidence provided at the November 4 hearing, not on the January, wait, when was it? Um, January 6th hearing, I guess. Anyway, doesn't sound right, but you guys know what I'm talking about. Custody. It is ordered that we shall continue to exercise joint legal custody. Next section. Custodial arrangement is defined as outlined in the parenting plan attached to Exhibit 1. So we're going to go through the parenting plan and get the details on that. Clothing exchanges. We shall exchange a bag with clothes and other items to make the child comfortable, including but not limited to, and then they included these items. These items shall be returned during the next exchange. You know, I wonder if this was a dispute, having this line entered here, because I can imagine myself thinking ahead, and I was like, I'm going to really need to make it easy for me to contempt my ex because she's going to steal these clothes, and she does, and I do file that motion. Our family wizard that we have to use, our family wizard. Child support, that she shall pay me child support in the amount of $471.57 per month. This is including her income, and it's also including the child support abatement, which is right here, the $100. I don't know why they call it a deviation. It's an abatement. In the statutes, you'll see it's called an abatement for relocation. All of the funds that are transferred between us, other than child support, shall be made by electronic funds transfer, which she doesn't make a single one. Not a single payment is made. All the money that we get is through the district attorney when he seizes it. So you can see how what the attorney was trying to do for her was really in her favor. He didn't care about me. He didn't care about her son, which it's not his job to care. It's only his job to care about his client. And so if he had successfully duped the court into making this the only way to collect any money from my ex, I would have ended up getting nothing. So at the very least, we were able to get those child support seizures for a short time because even those ended. Outstanding flight expenses. Let's see here. My ex shall provide me with proof of the outstanding flights, and I am to reimburse her for half the expenses. So guys, if I remember correctly, she never does provide this proof, and I never end up paying these costs for these flights, unless I'm mostly sure of that. And I know for sure that she didn't provide me proof for some of them, but I suspect strongly that she didn't provide me proof for any of them. We'll find out. I'm sure it'll come up in the case. My motion for order to show cause and her attorney fee award. So this is just going to go through the procedure, which was my non-opposition to the amount, $17.15, and then these amounts, the $17.15 that she is owed, get eliminated through offsets. So we go through all of these monies that she owed, and we reduce the attorney fee award, it looks like. In any event, none of this matters because this is going to get overturned on appeal. So we're going to talk more about this attorney fee award when we go through the Supreme Court appeal. We've got that she's going to attempt to recall the $350 cashier's checks that were never received by me, and that if she's successful, that she shall provide them to me. We have the miscellaneous orders and mandatory. So this is actually weird because it makes it seem like if she's not successful, she just doesn't have to pay it. But that's probably what her attorney angled for. If you want to know more about why attorneys do this, watch the video on the topic Win at All Costs. Next, we have miscellaneous orders and mandatory languages. Parties shall be responsible for their attorney fees and costs. What? Oh, this is just specific to the hearing that we went through, the hearing where she hired her attorney. It's ordered that the terms of the order resolve outstanding issues between us. Let's see. The parties are hereby notified of the following. And I think this is the boilerplate. Yeah, you can't run off with your child or you're committing a crime. And this is the Hague Convention. So this is also boilerplate, guys. There's a statute that says this stuff needs to be included in every single court order involving the custody of children. I guess this is new. I don't know if this was legit boilerplate, the rules on relocation, the 125C.200. Usually I don't see that included at the bottom of the orders. Usually it's just the don't run off with your kid thing and the Hague Convention on Child Abduction thing. Party obligated to pay child support can be subjected to the child support enforcement collections. Good. And that pursuant to the law, each of us may request a review of the order every 3 years. This is misleading. It makes it seem like this is the only time you can ask for a review, but it's not true. You can ask for them anytime there's a substantial change in circumstances also, even if it hasn't been 3 years. We got the judge here. We got the submitting attorney here. Minor child. Okay, so this is the parenting plan, guys. It's going to take us a while to go through this because I really wanted to make sure that you would actually get a much more detailed analysis on this. And I know I skipped it for all those proposed orders. All right. Let's see. It identifies myself and my ex. It identifies our child. Custody arrangement. Parties shall share joint legal custody. Legal custody involves, and then it goes into the basics as to how legal custody works. I shall have primary physical custody, subject to my ex's visitation. Here's the visitation. Global priority. If there is a conflict with 3 different sections, oh, I see. If there is a conflict with the different sections of the custody schedule, the governing hierarchy is from the highest to lowest as follows. So the major holidays win over other conflicts always. The second tier is individual days, major. So that's what, Mother's Day, Father's Day. Oh, because I guess it's possible for Mother's Day, Father's Day to, I don't know why he would put that in there. I'm not sure that they ever overlap with anything, but maybe they do. Followed by 7-day vacation periods, and then followed by the standard custody visitation. This actually makes sense. This is pretty cool. Now that I know how this global priority thing works, I think more I think more parenting plans should have them, because to me there are problems when these things overlap, and a high conflict ex will try and say, oh, well, I called a vacation day on your holiday day, so I get the child for Christmas, even though I'm not normally supposed to. That kind of stuff does happen. So this is a nice little thing that they had here. Alternating custodial visitation periods. Effective immediately, my ex shall have visitation on the 3rd weekend of the month, from Friday, when our son gets out of school, until Sunday. So that's Friday, Saturday, Sunday on the 3rd weekend of each month. That seems fair. If there is an issue with her exercising visitation, the court will entertain a short conference call to resolve the issue. This is the kind of stuff that makes no sense. Let's make the court the mom. Let's make the court the parents. There's no way in a high conflict case a court would want to do this. There would be conference calls all the time. After the year 2015, my ex will provide me with notice of which weekend she wants to exercise visitation on. For example, she'll provide notice of which weekends she'll be exercising visitation on during the year 2016 by no later than December 31st, 2015. The court will entertain a conference call if there's a disagreement as to which weekends she'll be exercising visitation. Both parties waive the right to an evidentiary hearing on this issue. Oh my God. Horrible. This is absolutely horrible. Why are attorneys doing this? Are you guys, oh my God. How can you prospectively waive your right to a trial? What about the best interest of the child? This is insane. This is like when attorneys were trying to say that you'd waive your right to ever modify child support. So this is actually, I hate to say it, but I have to be honest. This is actually a strike against my own attorney. She should have known better than to allow that in there. This is most likely not enforceable. This wasn't even discussed. Guys, this wasn't even discussed at any point. I can't even remember if this was put into any of the objections that were filed or the proposed orders. I feel like this was just kind of snuck in here. I'm not going to go back and check now. I don't have time for that, especially since my case is over and my ex's parental rights were terminated. But this is very alarming to see what attorneys can do when this is a complete shock to me. I cannot believe that this is in here. Wow. That should not be there. Anyways, I don't think it's enforceable. I think if somebody tried to say Alex waived his right to an evidentiary hearing because it's in the parenting plan, the Supreme Court of Nevada would say that's so unconstitutional that we're not even going to enforce that. Let's go ahead and move on. Let's see here. All of the Monica's. So it looks like it's going to be. Okay, guys, I don't know what to tell you about this because she never complied with this. So you see how it says here that she's going to provide me notice of which weekend she wants. She never actually complies with this, so it never turns into a fight. She just ends up showing up randomly and asking for time. I'm going to go ahead and continue. If a parent's custodial visitation time lands on a 3-day weekend recognized by our son's school, the parent shall have custody with him for the entire. Oh, okay, I get it. So for 3-day weekends, you get that third day. You get that extra third day. That's fine. Parties are encouraged to cooperate and decide upon additional visitation. Okay, that's nothing. Why is that even in here? Individual days. So Mother's Day. So I shall have visitation every Father's Day, and she shall have custody of the child every Mother's Day. From Friday prior to Mother's Day, ending when the child is dropped off the following Monday. So it looks like Mother's Day for her turns into like a whole week. Like, what if Mother's Day was, well, it would be on Sunday. So nah, that's fine. Major holidays. Parties shall divide major holidays in the following manner. So guys, if you oh wow, there were a lot more that she wanted on here. So there's just 5. But yeah, it looks like we alternate just odd years, even years each time we switch. Halloween. So guys, this goes into the detail as to the specifics on when the child picks when the parent picks the child up for the holiday and when the child goes back to the other parent at the end of the holiday. But for the most part, the holidays are alternated as defined up here, and these specific provisions just go into the specifics as to the times for pickup and drop off. So we got Halloween, we got Thanksgiving, we got winter break. I mean, I guess I could go through winter break in more detail. Parties shall equally split the time during the winter break period. The winter break begins when the child gets out of school on the last day of school. So it would start on a Friday, I would assume, and will continue on the morning of the day when the child returns to school. So the Monday. A parent who has Christmas Day shall have the first half of the break, and the one who does not have Christmas Day shall have the second half of the break, as follows. If the, what? Why is it so complicated? If the winter break includes an odd number of days, the additional day shall go to the parent entitled to Christmas Day custody. In such years, exchanges shall occur on the last day of the first half of winter break. For example, if winter break is 21 days long, the parent entitled to Christmas Day shall have the first 11 days, and the other parent shall have the last 10 days. Okay. If the winter break period includes an even number of days, the parties will split equally. Winter break. In any case, if the exchange day outlined lands on Christmas Day, the exchange shall occur on December 26th. Okay. Spring break, Easter Sunday. Spring break is defined as commencing at 9 a.m. 2 days before the official start date of spring break as designated by the child's school. Fall breaks. If the child attends a school that recognizes fall break, which I don't think Clark County does, I'm pretty sure they don't because I've never heard of this and I went to school here. 7-day vacation periods. Both parties are entitled to 7-day vacation periods during the calendar year as follows. The party wishing to exercise his or her vacation must notify the other party of the intent to exercise at least 30 days in advance. If the parties want to take the same dates for their vacation, I shall have the first choice of dates in even-numbered years. My ex will have the first choice of dates in odd-numbered years. That's cool. That's smart to have in there for high conflict, guys. The parties are prohibited from taking vacation at a time which would interfere with the child's schooling, which is good. If either party does not exercise their vacation period during the calendar year, it's forfeited and cannot be used following year. That's good too, because sometimes you'll have a high conflict ex that just doesn't care about the child, and then all of a sudden they'll want like a month. I don't think this would occur very often though, because usually they use the child for the conflict. Finally, each party will make 2 vacation periods per year, lasting a maximum of 7 days per vacation. Parties will take only 2 vacations per year, and neither vacation can last more than 7 days. That's fine. So what they're saying is you can't blob them. You can't do like 2 7-day. You can't do your 2 7-day vacation periods back to back to turn it into a 14-day. That's what they're saying. Summer vacation off-track time, except as otherwise stated herein, the parties do not make specific visitation arrangements for the child's summer break from school. Exchange location, it'll be determined by my ex if she's visiting in Las Vegas, and by me if I'm traveling to Reno. She did try to make this somewhat uncomfortable for me, but I didn't care. I just complied with the order. So I think she would try to make it at a location that was at the maximum distance. I remember it being like on the strip even, really uncomfortable location. Didn't matter though. If our son is traveling from one parent to the other without supervision, he'll travel by plane, and exchange will occur at the airport. Telephone and email access. My ex can provide him with a cell phone and is solely responsible for any financial obligation related to the cell phone. Yes. I shall ensure that the cell phone is charged and available to him to receive calls if there's any issue with the phone, and they are unable to speak during the day. The parties will cooperate to ensure she's able to speak. 5:30 p.m. each evening. The parties may mutually agree on a different time. This is going to matter in a hilarious way. This is going to matter. I wonder if it comes up. You know what? It doesn't come up in court, so I need to talk about this. There's a time when she's calling at 5:30 and he's playing with friends outside, and I keep telling her he's playing with friends. I don't tell her she can't talk to him. I just take the phone out to him, and he does talk to her on the phone. But she complains later. She says, "You know what? Every time he's playing with friends, he's in a rush to get off the phone." So she's like, "Can I just talk to him before bed instead?" And this isn't our family wizard. This is not verbal. So it's in writing. It's documented. So I'm like, "Sure, I'll start calling you right before he goes to bed." So I call her right before bed. She talks to him for a really long time. It was a great call, I think. Hang up the phone, and then as soon as she hangs up, I get an email from her, and it says, "You're in violation of the court's order," because I was supposed to talk to him at 5:30 p.m. And I remember thinking, what is wrong with her? So then I replied and said, take a look at your message from yesterday. Your message from yesterday, you actually asked for this, which is in compliance with the court's order. So she completely forgot that she did that. And this doesn't come up in court, so I have to talk about this now, or it won't. You guys won't get to see it. Later on, I remember we went to a possible parenting coordinator. If you guys want to know more about parenting coordinators and my positions on them, please watch my video on the topic parenting coordinator. I strongly recommend against using them. Anyway, this situation, we did talk to a parenting coordinator because she was thinking about coming on the case, and she never did. Don't worry. What happened at that specific meeting, I remember, is she brought her husband in. So I was there alone, and she was there with her husband, and the coordinator was like, "Ma'am, this is just for the parents. He really doesn't need to be in here. Please have him wait outside." And my ex refused. And she said, "No, I'm not going to do this unless he's allowed to be here with me." And she also said that I really need him for emotional support. And I also need him to help me because I usually forget things. And I thought to myself at the time, what a stupid excuse. She's just trying to have this guy in here because she's saying she can't remember things. But then years later, after the fact, I thought about it, and with the benefit of hindsight, I think that there may be something to what she was saying. I have a feeling that in some way, shape, or form, her mental health issues were so severe that her brain wouldn't remember things that were detrimental to her. Like, she needed an opportunity to hold me in contempt. And so she said, "You should have called me at 5:30." But her brain, like, probably forgot that other message that she sent me, because normally I don't think she would want to make such a fool out of herself with something in writing. And I never forgot that. Now, in hindsight, I often think to myself, there was probably some serious mental health issues going on. They were still a problem. They were especially damaging for our son. And it explains why she believed her own lies. It explains why she was so able to convince the court, because she herself had like a selective memory that she just I think I talked to another viewer about this before. He's posted comments with regards to Sam Vaknin and personality disorders, and I wish I could remember this viewer's name, but he used to refer to it as he refers to it as confabulation. I guess he got the word from Sam Vaknin. If you want to know more about my view of narcissistic personality disorder, please watch my video titled Narcissistic Personality Disorder. But I guess that somehow confabulation is the term that is used with the mental health profession on this particular, I guess you could say, problem, disability in a way. Anyway, I'm going to go ahead and move on. Education arrangements. Both parties shall be committed to quality education for our son, and we'll discuss any decision regarding changes of school. Both parties have the right to participate in school conferences, events, activities, and the right to consult. So this is one of the provisions that my ex exploits in the beginning. For the first few months, she's here all the time. She just uses the school to have contact with him, and she would sit in the lunchroom and have lunch with him. And I remember that embarrassed him, because all of his friends would be like all awkwarded by it, and they wouldn't hang out with him, and it would just be her and him at lunch. And it was a very strange situation. There were other parents, not many. I remember one other parent who tried to do this, and the principal told her to stop. Anyway, I'm going to go ahead and move on. Both parents shall have complete access to any and all school records and the right to be informed of any school parent activities. Okay, so I guess this is, okay, I get it, like meetings, like open house, special events, stuff like that. Details of any emergency meetings regarding our son will be sent by email to the other parent with a text message sent to emergency designated phone numbers to notify the other parent of the... Oh, I get it. Emergency meetings. So like a meeting that just kind of jumps up without any warning. Medical arrangements. I'll make arrangements for our son's regular medical dental appointments. Dentist, primary care physician shall be in Vegas. My ex shall make arrangements with her son regarding vision-related appointments. She never actually does this, and at least 2 motions get filed on this. So just hang in there. She fought really hard for this right that she just doesn't even bother to exercise. If an issue arises that requires expedited or emergency attention, that parent can make an appointment. Okay, this is pretty standard. Attorney fees. Each parent shall be entitled to attorney fees and costs if there is a finding by a court of competent jurisdiction that either party has violated the parenting plan. Okay, this is what I was talking about. I didn't appeal this because this is actually consistent with the contempt of court statute. But don't let the judge force contractual agreements down your throat like this, especially if it is damaging to your case. So in Nevada, contempt of court there's a statute that states that if you successfully hold the other parent in contempt of court, that you are entitled to attorney fees. And so this is, for the most part, as far as I know, still in effect based on the law anyway, even if it wasn't here. There are still some issues that I have with it. So for example, if the law changed, say the legislature changed the law and removed that law, now I would still be stuck with it because it's in this provision. And then the other thing is the same law states that the court doesn't have to do it if it doesn't want to, if it thinks that that would put the other parent into like a financial, there's a word they used. Anyway, that the other parent is just so poor that it would cripple them. And so this provision gets around that part too. So in hindsight, maybe I would appeal this. Maybe I would. And I would love to see if anyone here has, because I know this happens in family court a lot. The family court judge will come up with contractual agreements and they'll say, well, it's in the best interest of the child for this contractual agreement to be in place. So I'm just going to force both of you. I'm just going to force it on you guys. And this isn't the first time I've seen this. I've seen the judges do this in other areas as well. And I'm interested to see if anybody has appealed that and successfully prevailed on appeal on that specific issue. I'm going to be doing a lot more research into this particular act that these family court judges are doing because I'm pretty sure that there's going to be some precedent out there on this. They do this in other areas too, like when it comes to parenting coordinators and when it comes to custody evaluators. There are contractual agreements that the parents have to sign, and the court forces those agreements down the parents' throats. And there has to be some way that somebody has to have appealed this before and it's published. I'm very curious about that. Miscellaneous agreements, transportation costs. The parties shall alternate paying the costs of 4 airline tickets for our son to visit. So she can only get reimbursement on 4 tickets per year. I really like this. This was a really smart thing to have in here because she would have flown like 25 times just because she wanted me to pay more money. Luckily, this provision limits her to 4 times. And in the end, she doesn't end up providing proof anyway. Next, we have my ex shall provide notice at least 60 days in advance when she intends to exercise visitation. She doesn't comply with this either. She doesn't give any notice. She just starts showing up. We're going to talk more about this. I think there may be a motion filed on it. I'm pretty sure there is, but I'm not 100% sure. Any frequent flyer miles that are gained are shared. Tax exemptions and credits. I claim exemptions on the 2014 tax year, and my ex alternates for every other year. Extracurricular activities. Both parties shall have the right to enroll our son in extracurricular activities. However, if one parent does not receive written permission from the other parent prior to enrolling our son, then he shall be solely responsible for the entire expense of the activity. I feel like this is fine. I have a video on the topic. It's titled Extracurriculars. Take a look at it for my opinions on it. It's a really tricky situation in high conflict cases. Taking the child outside of the residential area. When a parent takes the child outside of the state, he or she will provide the other parent an itinerary. This is pretty standard. Support each party's role as a parent. This is consistent with there's a best interest factor. It says that you're supposed to facilitate contact with the non-custodial parent. So this here is consistent with the law. Emergency situations. Both parents agree that they will inform the other of any emergency or other significant event. Okay, I guess this is like for ER visits and stuff. Communication regarding custody. All communications shall be between the parties whenever possible. That's good. Then the parties will not use our son to convey information. She violates this provision, and I filed a contempt motion on this. We'll go through that in detail when you see that motion. Future disputes. Each parent will exert their best efforts to work cooperatively in the future. Okay, that's fine. Modification. Parties are encouraged to attend mediation. Sorry. Oh, I see. Encouraged to attend mediation prior to filing. Okay, that's fine. It's not enforceable. Makeup visitation. Let's see. A statute will govern any dispute regarding claims of makeup visitation. That's fine. Severability. If any provision or any part of any provision of this plan shall for any reason be held to be invalid, the remainder of the parenting plan shall not be affected. Governing law and venue. The parenting plan shall be interpreted in accordance with and governed in all respect by the laws of the state of Nevada. The state of Nevada shall remain his home state pursuant to, and these are jurisdictional things that have been put into place by the federal government. As far as I know, the UCCJEA is a federal act. Anyway, let's continue on. Certificate of electronic service, which is indicating this document was was electronically served upon my ex's attorney and was mailed to my attorney. Next we have substitution of counsel, substitution of attorney. My ex is withdrawing as the attorney of record for me. I'm not an attorney. That's what I was trying to say earlier, guys. I don't think that you're allowed to do this. I don't think lawyers can file a substitution of counsel to substitute themselves out for their client. It's fine. What we could have done was a stipulation to withdraw. That would have been fine. And then the difference is the court needs to be involved in this process and the court needs to approve it. But I don't think that this is actually out of, what's the word I want to use? I don't think this is actually a concern anyway, because I don't think there's anything pending at this time. And so she should be able to just file a notice of withdrawal. Attorneys are allowed to withdraw from a case if there's nothing pending. So at this point in time, right now, there should not be any appeals pending and there should not be any motions pending. So she would probably have been fine just doing a notice of withdrawal. And that doesn't need the court's approval, and that would have been, above board anyway. So this isn't really a harmful mistake in any way, shape, or form. It's just, I think that this mechanism is not, it can only be used between two attorneys. And the purpose of it is to just quickly swap out lawyers without having to waste the court's time. When you're getting off the case and leaving your client without an attorney, the judge has to be advised as to what's going on, depending on whether it's by motion or stipulation between the client and the attorney. The judge has to approve it. If you want to learn more about this, please watch my video on the topic removing an attorney. We got the affirmation pursuant to Rule 239B.030. And we have the certificate of service indicating this document was mailed to my ex, well, her attorney. Errata to substitution of attorney. Failed to state that my address is where all okay, I get it. So this is just her stating that all future papers should be served upon me, and here's my address. This is an old address, guys. I don't live here anymore. So, I mean, we're starting to get to the point where we're getting close to my current stuff, but this is still many, many years back. Affirmation. This is indicating that there's no social security number in this document. And then we have this certificate of service indicating this document was also mailed to my ex's attorney. An amended errata. Something else is wrong here. Oh, so I guess she put the wrong address. Let me check really quick. It looks right to me. That's not the wrong address. This is the right address. So, affirmation pursuant to Rule 239B, indicating this document does not contain a social security number, and rules of another certificate of service indicating this document was mailed to my ex's attorney. Notice of entry of order. This is entered by my ex's attorney, and what this does is it sets the timeline. It starts off the timeline to file an appeal. It also does a few other things, but the most important thing relevant to my case is that this is now going to start the clock ticking. This notice of entry of order is indicating that the order entered by the judge that we just went over is notifying me specifically of that order that the judge entered. We have a certificate of service under Rule 5 indicating this document was mailed to me. We have the index of exhibits, which contains an order following June 29 hearing. And this order is the exact order that we just went over 4 documents ago. So I'm not going to go over it again. As with my previous videos on the My Docket series, you can go down into the description below. You can find the links to these documents. You can always click on them yourself, download them, take a look at them yourself. And if you see something in this that stands out to you that you want me to talk about, just mention it down in the comments below and I'll do that. Notice of entry of order by my attorney. So my attorney is doing the same thing. She just wants to make sure that the time we probably filed this like at the same exact time. Anyway, guys, another notice of entry of order. By the way, if you wanted to learn more about the details of the notice of entry of order, I do have a video on the topic titled Notice of Entry of Order. Certificate of service indicating our notice of entry of order was mailed to my ex's attorney. Notice of withdrawal and of consent of electronic service. So I had a notice of consent to electronic service on file for my ex's attorney, Catherine Burning. Catherine Burning and I had much more cordial of a relationship than her new attorney. Her new attorney just didn't return calls and didn't care. And so I didn't trust him. I trusted Catherine Burning a lot more. And you guys know that I felt Catherine Burning did a number of conniving things in my case. Despite those things that she did, this guy's even worse. So I decided to withdraw my consent to electronic service. I didn't want to have him trying to use anything against me because I kind of felt like he took win at all costs to another level. And so this is just me withdrawing consent to that under the local rules, and now the documents have to be mailed to me. Rule 5, certificate of service, and this is indicating that I'm mailing this withdrawal of consent to this attorney. Notice of appeal. You guys knew it was coming, and here it is. Now that the judge has entered an order granting my ex a specific dollar amount of attorney fees, I am able to file the notice of appeal. The issue is now ripe. We're going to talk more about the technical details as to why I didn't file the notice of appeal earlier when the judge ordered attorney fees against me. Why did I wait until after the judge entered the specific dollar amount? There's a reason why, and we're going to talk about this a lot more when we get to the jurisdictional statement in the opening brief. But we're not there yet, so hang in there. We got Rule 5, certificate of service, indicating that this document was mailed to my ex's attorney. Actually, there's one more thing in here I want to talk about. Yeah. Okay, so you see this little footnote here, this that I'm appealing only the attorney fees awarded, and I have a little footnote. We're going to go down here, and it says the only portion of the order that is being appealed is the court's award of attorney fees in favor of my ex and against me. No other portion of the order is being challenged on appeal. The reason I did that is because I wanted to make sure that the judge still had jurisdiction over all the other issues, because I knew that I was going to be filing a multitude of motions. And I didn't want this judge to try and say, oh, well, it's on appeal now, so I can't do anything, which a lot of family court judges will do. So what I did was I put this footnote, and I wanted to make it clear to this judge and the Supreme Court that the only portion of that order that is being appealed is the attorney fee portion. That means that the only portion of that order that this judge is deprived of jurisdiction on is the attorney fee award. If you want to learn more about why this matters, please watch my video on the topic, Jurisdiction Divested on Appeal. Next, we have the case appeal statement. I don't know why I filed this. I'm not supposed to do this. This is something that the clerk of the district court is supposed to do for me. So don't do this because it's in violation of the rules. The rules of appellate procedure require attorneys to file a case appeal statement when you file an appeal. However, that same rule that I just mentioned also says that if you do not have an attorney and you're representing yourself, that you do not do this. The case appeal statement is instead going to be prepared by the clerk of the district court. And so we're going to probably see another one of these pop up in this case, and that's going to be the one that's done by the clerk of the Supreme Court. Anyway, I went ahead and did it. And I've gone over case appeal statements before. If you guys really want to, you can go through this and mention any questions you have down in the comments below. But these specific lines are mentioned by the rules of appellate procedure. In other words, I didn't just kind of think I'm going to tell them, all these things and I just put them in writing. The rules specifically say, you must say, who is the appellant? Who is the judge that made the decision? Who is the petitioner? Who is the respondent? Who's involved in the appeal? So these lines here are specifically mentioned in the rules of appellate procedure for me to include in the case appeal statement, or the attorney, if an attorney is doing it. Same for the clerk of the Supreme Court. So if you want to know more about why this was prepared so specifically, you really have to get into understanding how the rules work, because the rules will tell you what to put in these statements. Rule 5, certificate of service, indicating that this document was mailed to my ex's attorney. And that's it. So we do have one thing. Everything with regards to the relocation was really already disposed of. All the judge did was kind of hash out the details. But one thing was disposed of, and that is my ex's request for attorney fees. And the judge has granted that motion. Going into the aftermath, we have 1, 2, 3, 4, 5, 6, 7, 8. Looks like 9 documents that were filed I filed one, two, three, four, five, six, that's a lot. I filed 7 of those documents. It's a surprise to me. Let me check that again, guys. So there's a substitution, the errata, the other errata, that's 3. One of the notices, that's 4. The withdrawal, that's 5. The notice of appeal and the case. Okay, yeah, that's 7 documents that I filed. Um, but those were free filings. So actually, the notice of appeal is not a free filing. Um, and I don't think I got the fee waived on that. I didn't. So that is going to be $250 in costs for me. My ex filed, it looks like one document. Yeah, just one document. My ex filed one document, and that's a free filing, so she incurred $0 in costs. I had an attorney, but she was representing me for free, so I incurred $0 in attorney fees. My ex's attorney would have had to review a few things, but for the most part, he would already know what's going to be in that order. So I'm going to just say 15 minutes for the order. The all the documents that I filed were pretty minor. I'm going to say 1 minute for each of those. So that's 1, 2, 3, 4. For the most part, I'm going to just add another 10 minutes. So we're at 25 minutes so far. Then we have the notice of entry of order that he prepared. 25 minutes, I think 5 minutes, rounding that up to 30 minutes for all of this for him to review, I think is pretty reasonable. So at the rate of $250 an hour, that's going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.